Brutal courtroom moment. Judge exposes Trump's lies one by one. Nobody saw this coming. Not his lawyers, not his supporters, not the political analysts sitting in their expensive studios. Not even the reporters who have covered every single twist of this legal saga for years. What happened inside that courtroom changed everything. A federal judge appointed by a Republican president looked directly at Donald Trump's legal team and said words that no defendant ever wants to hear. He said them slowly. He said them clearly. He said them for the record. And the silence that followed was the loudest thing in that entire building. Every journalist in that press gallery stopped typing at the exact same moment, because what they had just witnessed wasn't legal procedure anymore. It was something closer to a public execution of a carefully constructed narrative that Trump had been selling to the American people for months. Let me tell you exactly what happened, because the way most outlets are covering this story is either too soft or too theatrical, and you deserve the precise truth. It started with a lie that seemed small. Trump had been repeating for weeks across Truth Social posts, in front of cameras, at rallies packed with supporters waving flags, that the gag order imposed by Judge Juan Merchan was preventing him from testifying in his own defense. He said it like he believed it. He said it like a man being silenced, like a man being gagged not just legally but politically. His team amplified the claim. His supporters shared it millions of times. It became a core part of the persecution narrative, the story that the courts were weaponized against him, that he wanted to speak but they wouldn't let him. There was one catastrophic problem with that story. It was completely, documentably, provably false. The gag order had nothing to do with Trump's right to testify. It restricted attacks on witnesses, jurors, and court staff. It was a standard protective order designed to prevent witness intimidation and jury tampering. It said nothing, not a single word, about Trump's ability to take the stand in his own defense. Any first-year law student could read it and understand that. Any journalist who actually read the document knew that. But Trump kept saying it anyway, day after day, post after post, rally after rally. And then came the moment. Judge Merchan addressed it directly from the bench, with Trump sitting in that courtroom, with cameras capturing every expression, with the official court record running. The judge didn't raise his voice. He didn't need to. He simply explained, with the precision of a man who has spent decades separating facts from fabrications, that Trump had the absolute constitutional right to testify, that nothing in any order issued by this court prevented that, and that the statements being made publicly about this matter were a misrepresentation of what the order actually said. He didn't say it once. He had to say it multiple times, because the lie kept resurfacing outside the courtroom even after being corrected inside it. That is what makes this moment so different from ordinary legal proceedings, and that is what the viral videos are trying to capture, even if they sometimes dress it in more drama than the transcript strictly supports. The underlying reality is this. A sitting judge was compelled repeatedly to publicly correct false statements being made by a defendant about his own case. That almost never happens. Judges don't typically engage with what defendants say on social media or at rallies. They operate inside the courtroom and let the legal record speak. But Merchan broke from that convention because the lie was so persistent, so widely distributed, and so specifically designed to mislead the public about what the court had actually ordered, that silence felt like complicity. Now understand what that means legally. When a judge corrects a false public statement from a defendant, that correction enters the official record. It becomes part of the documented history of the case. It means that years from now, when legal scholars study this trial, they will find a judge on the record stating that the defendant made false claims about court orders. That is not a political opinion. That is not partisan commentary. That is a formal judicial finding, entered into the permanent legal record of the United States court system, that Donald Trump said things that were not true. And Merchan was just the beginning. The contempt orders tell an even darker story, and this is where the pattern becomes impossible to dismiss as isolated incidents or misunderstandings. Merchan held Trump in contempt not once, not twice, but at least 10 times for violating the gag order. 10 separate findings. 10 separate legal determinations that Trump had crossed a line the court had explicitly drawn. In those contempt orders, the judge used language that should stop everyone cold. He described Trump's social media posts as incendiary untruths. Read those 2 words carefully, because each one carries enormous legal weight. Incendiary means designed to inflame, to provoke anger, to potentially inspire dangerous reactions against the people being targeted. Untruths means false statements. The judge was formally finding that Trump was deliberately posting things that were both false and potentially dangerous. That is not a harsh opinion piece. That is a legal conclusion reached after reviewing evidence and applying established standards of law. Each contempt finding came with fines. Each one came with explicit warnings that continued violations could result in incarceration. Merchan stated clearly that Trump's status as a former president, or as a presidential candidate, did not exempt him from the consequences of contempt. The court would jail him if necessary to enforce its orders. Think about what that means in the context of American history. A federal judge warning a former president of the United States that he faces imprisonment for repeatedly making false statements designed to intimidate witnesses and inflame public sentiment against court officers. That is not normal. That has never been normal. And the fact that it became almost routine in the coverage of this trial does not make it less extraordinary. Then there is the civil fraud case, which adds another layer to this pattern that cannot be ignored. Judge Arthur Engoron's ruling in the New York civil fraud case was methodical in a way that the contempt findings were not. Where Merchan was responding to specific violations in real time, Engoron went through the Trump Organization's financial records the way a forensic accountant goes through a crime scene. He examined specific properties. He examined specific valuations. He examined representations made to banks and insurance companies about the value of assets. And property by property, claim by claim, number by number, he found that the statements were false. Not mistaken. Not imprecise. False. Materially false in the legal sense, meaning false in ways that mattered. False in ways that affected decisions. False in ways that caused financial harm to the institutions that relied on them. That ruling is the closest thing to the one-by-one moment the viral videos describe. It reads like a document where a judge goes through a list of claims and marks each one false with the evidence to support that conclusion. The Mar-a-Lago valuation. False. The Trump Tower apartment square footage. False. The Seven Springs estate appraisal. False. Engoron didn't use theatrical language. He used something more devastating, which is the cold, precise language of documented proof. He wasn't destroying Trump's lies with outrage. He was destroying them with math. But the pattern doesn't stop at the New York cases. Federal judges reviewing Trump administration arguments in 2025 and 2026 have used language that legal analysts describe as extraordinarily harsh by the standards of federal judiciary. One judge stated that administration claims about emergency authority were completely untethered to reality. That phrase deserves its own paragraph. Untethered to reality. Not incorrect, not legally insufficient, not even wrong. Untethered to reality, meaning your argument has no connection to the world as it actually exists. That is a federal judge saying, in formal legal language, that the position being argued before the court is essentially detached from factual existence. Multiple federal judges have questioned whether they can trust representations from Trump's Justice Department. This is where the accumulation becomes something structural and not just individual. Federal courts have historically extended significant deference to Department of Justice attorneys. There is a professional assumption that government lawyers operate in good faith, that they verify facts before representing them to a court, that officers of the court maintain a baseline of honesty with judges, even in adversarial proceedings. Trump's administration has damaged that assumption to a degree that legal scholars describe as genuinely unprecedented. Judges are now publicly saying they require additional verification for claims the DOJ makes, because the track record of accurate representations has been compromised. When judges don't trust your lawyers, everything in litigation becomes harder. Every motion faces more scrutiny. Every claim requires more documentation. Every request for favorable interpretation gets denied because the goodwill that normally lubricates the legal process has been spent. And credibility, once lost in a courtroom, does not return easily. Each judge who formally finds false statements makes the next judge more skeptical. Each contempt finding makes future courts less willing to extend benefit of the doubt. The damage compounds across cases, across jurisdictions, across time. Trump's response to every one of these findings has followed the same template. He doesn't correct the record. He doesn't acknowledge the judicial findings. He doesn't modify behavior to bring himself into compliance with court orders. Instead, he attacks. The judge is corrupt. The case is rigged. The finding is persecution. The system is weaponized. He repeats the same false claims that generated the contempt findings in the first place, then cites the contempt findings as evidence of bias against him. It is a closed loop of dishonesty where every correction becomes new ammunition for the persecution narrative, and every new lie generates a new judicial finding that feeds the next cycle. Legal analysts note that this response pattern itself is legally significant. When someone makes an honest mistake and a judge corrects them, the normal response is to stop making the mistake. When someone continues making the same false statement after multiple judicial corrections, it demonstrates knowledge of the falsity. It shows the speaker understands the statement is wrong and chooses to continue anyway. That is the legal definition of deliberate dishonesty, and judges across multiple cases have documented exactly this pattern with Trump's statements. So what does all of this actually mean for accountability and for you? It means the brutal courtroom moment is not one scene. It is 100 scenes accumulating into an overwhelming record. It is Judge Mershon correcting the gag order lie and then watching Trump repeat it outside. It is 10 contempt findings with language about incendiary untruths. It is Engoron going through valuations one by one and marking each false. It is federal judges saying arguments are untethered to reality. It is the entire federal judiciary's trust in DOJ representations eroding in real time. Each moment alone is significant. Together, they constitute something historic, a documented judicial record establishing a pattern of deliberate dishonesty from a man who wants to return to the most powerful office on earth. The truth, stripped of theatrical packaging, is more damaging than any dramatization. Judges don't call things incendiary untruths lightly. Judges don't hold defendants in contempt 10 times for honest mistakes. Judges don't describe legal arguments as untethered to reality unless the departure from reality is severe and documented. The viral videos that describe brutal one-by-one exposure of Trump's lies are dramatizing something real. But the real thing doesn't need drama to be devastating. What happened in those courtrooms, slowly, methodically, on the record, is the closest thing American democracy has to an official truth-finding process. And the truth it found was damning.